The most recent English-language XRP news report from CoinMarketCap is used to explain everything in this video. Have a peek at this other XRP. In the course of the continuing legal battle between Ripple Labs Inc. and the United States Securities and Exchange Commission concerning the standing of XRP, the agreement between Ripple and the SEC allowed for the construction of a distinct XRP case. There has been a request from both parties to have the records sealed by the U.S. District Court for the Southern District of New York. This is all a part of Ripple's effort to conceal Bitcoin relevant information regarding the sequence of events in their continuing legal dispute with the SEC. Problems with redaction and sealing can be addressed with briefings about possible remedies using this idea, which is a step-by-step method. By adopting this approach, all parties demonstrate their understanding of the need for secrecy in certain situations while maintaining their dedication to transparency and candor. The establishment of a date for the forthcoming court hearings is a new and significant development in the continuing legal dispute between Ripple Labs and the United States Securities and Exchange Commission. All the due dates for submitting and making public court records are included on this calendar. The proclamation recognizes the necessity to redact private information, while also stressing the importance of openness. The Securities and Exchange Commission intends to submit its opening brief regarding solutions behind closed doors beginning on March 22, 2024. Professionals will review the work before it is released to the public. During this stage, you should look for any private information that has to be removed from the document. To better prepare for the review portion, it is helpful to set the scene beforehand. In addition, it lays the groundwork for a potential legal dispute between Ripple and the SEC, while also displaying proactive measures to safeguard personal data. A significant milestone will be reached on March 25, 2024, when individuals will begin collaborating to resolve the issue of redactions in the SEC opening brief and related documents. Giving people as many opportunities as possible to reduce the amount of redactions is the purpose of these efforts. By working together, all parties concerned in this issue have demonstrated their dedication to transparency and fruitful discourse. On March 26, 2024, the sanitized opening brief of the Securities and Exchange Commission is expected to be released to the public. All permitted redactions will be present in this version. Taking this measure guarantees that crucial information is accessible to all while safeguarding personal data, which in turn encourages increased transparency. On April 22nd, the opposing side's brief and supplementary materials are due. If current trends continue 2024, these data will still be accessible to the public, but any potentially sensitive material will be concealed. When dealing with a convoluted legal system, this is what occurs. Due to the difficulty in maintaining anonymity while being truthful, this method is not easy to utilize. After then, on March 23rd and 2024, discussions and documents pertaining to the redaction of Ripple's opposition brief and other documents are expected to commence. The purpose of these discussions is to allay people's concerns over the security of their personal data. Consequently, this will contribute to the improvement of the existing requirements for transparency. On May 6, 2024, the EMS, the Internal Management System of the Securities and Exchange Commission, would submit its reply brief under seal. It is expected that this will be the final entry sent. From May 13th through the 20th, 2024, the main focus will be on sending motions to seal papers relating to the remedies briefing through omnibus letters. Filing written briefs expressing disagreement with motions to seal materials is the subsequent stage. There will be a discussion over the necessity of sealing specific documents and data, as well as the appropriate level of sealing, because XRP is currently being litigated with other parties. Going forward, the bulk of the correspondence will be on revising and disseminating publicly available versions of the Secretary's reply brief that omit some details. Both public and private information will be shielded from harm in this way. Using this predetermined window of time, you can maintain both public and private profiles. By their actions, the parties have demonstrated their dedication to maintaining communication open throughout the XRP legal process. Finding a method to secure private law and company documents while allowing everyone to access publicly available information is the primary objective of the joint sealing proposal. A transparent set of guidelines for concealing and releasing information will be established to facilitate this. Bill Morgan, a perceptive member of the XRP community, has divulged a crucial piece of information regarding the case. With a protection order in place, no one other than the SEC may view the specifics of Ripple's post-complaint arrangements with institutions. This persists, despite the fact that the SEC has publicly requested the disclosure of these contracts. Morgan has noticed that Ripple is likely to request the sealing and concealment of critical firm data in the short and reply briefs it provides to the Securities and Exchange Commission (SEC). This is a natural progression for the XRP instance. Even when all parties are being truthful, the joint ceasing request and planned timeline respects the need for privacy while enabling open court procedures. The combination of these two elements creates an unambiguous foundation. As the case's observers anxiously await fresh developments, protective orders give the impression that some aspects of the case are particularly sensitive at the moment. Adherence to a transparent and rigorous procedure ensures the security of sensitive data and facilitates simple access to critical records. When it comes to the XRP situation, a joint motion to dismiss the action has been submitted by Riverside Landings and the United States Securities and Exchange Commission to the United States District Court for the Southern District of New York. The judge hearing the Elisa Torres case was informed of the proposed method of submitting and making public court records in a joint letter dated March 19, 2024. The parties reached a consensus to postpone discussing the solution until the next briefing. Taking full use of this opportunity, protecting the names of those involved with sensitive material is crucial, and everyone will be able to demonstrate their commitment to transparency by doing so. In order to clarify their respective aims, the parties have prepared the following statement: the importance of being cautious while sealing and redacting papers is also emphasized in the letter. The parties' papers will be made public promptly according to the plan. The public should have unfettered access to them, thus any proposed redaction should be minimal. The deadline for Ripple to exhaust its special remedies against the SEC is March 22, 2024. Prior to the records being made public, the Securities and Exchange Commission must transmit all supplemental materials, including documents, statements, and the opening brief on remedies, under seal. As a first step, everyone involved can review the materials and determine whether any sensitive information has to be kept secret. A great deal of confidential, encrypted private sector information is likely to be contained in the SEC brief and reply brief. Reason being, the information could be sensitive. Do not rely on this information as a trading recommendation or basis for any investing decisions.